Okay, good afternoon, ladies and gentlemen. I hope we are all well. Please look excited. This is a session to learn many new things. Okay, so my name is Martha Odwor from the Corporate Communications Office, and I have the pleasure of welcoming you to our 4th edition of the Knowledge Café series, which we are co-hosting in collaboration with Strathmore Law School. Yeah? So for those of you who may be wondering, what is Knowledge Café all about? I'm sure for some of you this is your first time in such a session. So allow me to unpack that a bit. We have been holding these sessions. This is the 4th one. And ideally, the Knowledge Café is supposed to help us reflect on some of the topical issues that are happening within our society. These issues affect us directly or indirectly, and therefore it is important that we have experts who help us reflect on these issues from a credible and objective perspective, so that as individuals, as laypersons, we are able to make objective decisions. We are able to partake in conversations knowing exactly what the issue is, yeah? So in the previous editions, we've explored themes such as the impact of Trump's policies, the relevance of mathematics in the curriculum, and most recently, how to navigate financial disruptions. Today, we turn to a critical conversation, a very pertinent one, on emerging technology, patents, pills, and people, intellectual property, and health in developing countries. So I know it sounds like a mouthful. Can you remember any of what I've said? Yeah? So today we'll be looking at the aspect of intellectual property, trade, and health, and how all these factors intersect to enable all those who are in most need of health innovations to access them more easily. And we have a very able panel that will help us to just have that discussion. Allow me to just introduce them. We have Janet Njambi, who is a teaching fellow at Strathmore Law School. We have Dorcas Chebet, lead researcher on intellectual property at the Center of Intellectual Property and IT Law. We have Claude Kamau, a doctoral fellow at Strathmore Law School. And we also have Dr. Melissa Muindi, the academic director at Strathmore Law School. I also want to welcome in a very special way our online audience who are joining us through our YouTube channel, so please feel free to engage with us as well. Dr. Melissa, I hand over this conversation to you.
Martha. So I have the pleasure of introducing the panel to you. I will read out their bios. I don't know why it's a bit shaky. I'll begin with Claude. So Claude Kamau Mwangi is a legal scholar and doctoral fellow at Strathmore Law School and a PhD candidate at the University of KwaZulu-Natal, researching legislation on benefit sharing in genomic and biobanking research in Kenya. He's the principal investigator of a 2.46 million National Cancer Research Institute grant on benefit sharing law, intellectual property law, and cancer research policy in Kenya, and a doctoral researcher with the Data Science for Health Discovery and Innovation in Africa Law Group, previously supported by a 500,000 Rand research grant. Claude has led the Digital Self-Determination in Mobile Money Technologies in Kenya project, funded by the Swiss Federal Department of Foreign Affairs, and collaborated on the Inclusion, Participation and Development project, implementing Kenya's Traditional Knowledge and Cultural Expressions Act under the Global Challenges Research Fund. He has presented his research at major academic fora, including the 2025 National Cancer Summit in Kenya, the Intellectual Property and Africa Conference at Harvard University, the Postgraduate Bioethics Conference at Cambridge, the DSI Africa Annual Conference in Kigali, and the Digital Self-Determination Conference in Turin. His publications appear in leading journals, there are quite a number, covering topics from benefit sharing in health research to digital rights and taxation of software copyrights. Claude's work bridges intellectual property, ethics, and health law, shaping policy debates on benefit sharing in health research in Africa. So we can give a warm round of applause to Claude. I think I'll just read through all the bios, and then after that, welcome each of the speakers to say a thing or two that touch on the topic at hand. And I'll move on to introduce Janet Njambi Macharia. So Ms. Janet Macharia is a lawyer licensed to practice in Kenya. She's passionate about international economic law and holds a master's degree in international economic law from the Academy of International Law and Policy in Athens, Greece, or Athens. Janet is currently a teaching fellow at Strathmore Law School, where she teaches international trade law, law of business associations, and company law. She also consults with the Trade Negotiations and Investments Forum, a young, independent, and multidisciplinary organization dedicated to promoting meaningful conversations, research, and capacity building on trade and investment within the continent. Janet also trains and coaches law students in the John H. Jackson Moot Competition, and in 2024, she led the Strathmore Law School team to the Globals in Geneva, where they won first place. Janet has presented research at leading forums, including the 6th Biennial Conference of the African International Economic Law Network, where she delivered a paper which was titled An Evaluation of the TRIPS Agreement, a Case for the Request for Waiver. Janet has advised on legal and policy matters in international trade law and investment, and contributed to the development of the Kenya National Investment Strategy. Her current research focuses on special economic zones, particularly subsidy regimes across African jurisdictions, and the interaction with the African continental free trade area. So a warm round of applause for Janet. And we also have Chebet Koros, and I'll also read her bio. So Chebet Koros is an advocate of the High Court of Kenya and holds a Master of Laws in Intellectual Property Law from Queen Mary University in London. She leads research on intellectual property law at the Center for Intellectual Property and Information Technology Law, CIPIT, in Strathmore University, with a focus on the intersection of IP and innovation. Her work seeks to shape IP policy in Kenya, contribute to regional reform initiatives across Africa, and engage in global discourse. Her current research explores Kenya's copyright law in the context of emerging technologies, continent-wide copyright reforms, and ongoing negotiations at the World International Property Organization Standing Committee on Copyright and Related Rights. She's particularly interested in how these developments can balance protection with public interest objectives, especially through limitations and exceptions to copyright. Beyond research, Chebet designs and delivers training in IP law and is co-author of a practical handbook on copyright protection in Kenya for creatives and IP practitioners. She's passionate about raising IP awareness, fostering knowledge dissemination, and promoting balanced approaches to the protection and use of IP assets in the public interest. So a warm round of applause to Chebet. And just so that you know who I am, I'm Dr. Melissa Muindi, Academic Director at Strathmore Law School, and I'll be the one moderating this very interesting discussion that we're about to begin. So for starters, I think a good starting point would be to set the stage for this discussion, and I'll give each of the panelists a few minutes to just give more general opening remarks, but I think I'll guide the discussion so that they just don't ramble on end. So for Claude, in terms of setting the stage, perhaps if I may ask you to explain what intellectual property is and why it matters to health. So that could be a good way to begin. Karibu. In 10 minutes or less.
All right. Thanks, Dr. Ari. Let me begin by timing myself, just so I don't hog the airtime. Thanks a lot. So the question relates to the intersection between intellectual property rights and health. It's obviously a very current and very meaningful question. But we want to find out to begin with what's an intellectual property right. By definition, an intellectual property right is a property right, yeah? Meaning it would fall somewhere along the spectrum of property as you understand it in the common law tradition. So it would that would mean either under a real property classification, which is land and things permanently affixed to land, and on the other hand, personal property. So obviously we know it doesn't fall under the realm of real property, so it would have to fall under the realm of a movable, and under personal property we have those two other minor classifications, which is things in action, movables, and things in action and things in possession, right? So both of those are movables. So IP is a thing in action, right? Meaning it's an intangible property, right? A right to creation of the mind, and more importantly, it's a monopoly right, yeah? So a monopoly right, as you would imagine, is a right that allows you to control, access, use, and pricing of a particular commodity, presuming it's a valuable and useful commodity. So then for intellectual property, this is a monopoly right which allows an exclusive entitlement towards creations of the mind which either solve a technical problem or enable thought expression. So if it's the solution of a technical problem, typically we consider that to be industrial property. If it's a solution or thought expression, we consider that in the realm of copyright and related rights. So what's the interaction between intellectual property and health? A useful way to think about the intersection is to perhaps look back and historicize this concept. Think about a couple of historical junctures in the recent decades to kind of put this concept into perspective and see what the interactions are. Now, as you've said, it's an IP right is a monopoly right. Monopoly rights necessarily produce certain societal losses, right, which is in the nature of a monopoly. But the reason why we decide sometimes to award the monopoly right is because the counterbalancing benefit to the individual creator or to the society at large justifies that cost, right? So if it's more, if the balance weighs in favor of the benefit either to the individual or to the society, we hold our noses and we accept the monopoly right. So what's the interaction between that monopoly right and health? So you can think of a number of historical occurrences. So in the early 1980s, you had a patent right that was granted over a technology that covered the isolation of a microorganism, a living microorganism that could break down proteins, could break down effluent from spillage of oil, which was the dawn of what we call biotechnological patents, right? A patent right will cover advances in technology, including biotechnology. And then soon after that, we had a famous act of Congress in the US called the Bayh-Dole Act in the mid-80s that empowered universities and beneficiaries of state funding to commercialize their patents. And this was notwithstanding the fact that the funding primarily behind these inventions was government funding. Now you realize that the problem here is that if the government has funded a particular project and you've come up with an invention under that project, then it would be presumed that it will be in the public interest and should be the patrimony of mankind, at least within that jurisdiction, that citizens should benefit from that invention or innovation sometimes. So then the question here, the early balancing question between IP and biotechnology came to the fore. Should we allow individuals to privately commercialize resources and knowledge, because IP is fundamentally knowledge, all IP covers bits of knowledge, should you allow individuals to commercialize this at the expense of the rest of society who might need interventions that are only accessible through the method or the product that is covered by that intellectual property right? And then a decade later, we had the Human Genome Program, which was an attempt to decode the human genome to kind of sort of uncover the blueprint of human life. And the questions here became broader. You know, should individuals have intellectual property rights over a genetic sequence, for example? Have you participated in creating a genetic sequence as a human being, or have you just discovered naturally occurring substance in nature? Yeah, so this led to a lot of litigation as well, and the area is still a bit contentious, but you have a bit of clarity now. But the more important questions for us relate to things that happened at the dawn of the new millennium. We have the HIV pandemic, whereby millions of underserved communities in South Africa, in developing countries such as Kenya, lost their lives because they couldn't afford at that point, standard treatment for HIV, which was antiretroviral medication. And South Africa, as an outlier, decided, we are going to prioritize the health of our country, and we are going to allow what we call parallel importing. We're going to allow compulsory licensing. We're going to allow genericization of ARV medication. And so obviously they were sued by 39 leading pharmaceutical companies from the West. And it was a very bad, or it reflected very badly on these pharmaceutical companies, especially in the wake of the intense public pressure at the instigation of developing countries and NGOs against this measure, right? And then after that, we had the influenza virus with the same kind of issues. You may or may not remember this, around 2007 or 2008. And then we had in Canada a similar problem where the BRCA gene, which covers, or which is responsible for cervical cancer, sought to be patented by a company called Myriad Genetics. Some of those patented were invalidated by the Supreme Court, but not after a lot of damage was done in terms of access to diagnostic kits by victims of breast cancer, not cervical cancer. And then ultimately we know what happened during COVID, the immense public pressure for the so-called TRIPS waiver to kind of allow or excuse developing countries from compliance with some elements or some requirements under their multilateral obligations under the TRIPS agreement, and the subsequent ministerial decision on this in 2022 that Jambi is going to talk about. So then what you can clearly see here is that IP rights ranging from patents to trade secrets to an extent copyright limitations and exemptions have important implications on public health. So then it's possible, it's kind of timely, and it behooves us to understand what those specific interactions are and how we can better situate ourselves in response to them as a developing country. I think I have 1 minute left, but I'll just pass it over to my colleagues.
Thank you very much, Claude. So, in fact, as you were talking, it made me think of some of the things which perhaps Njambi can talk about, because you talked about ARVs and influenza and, what the policy measures were, and perhaps this can be a good point for Njambi to add the trade policy perspective. So Njambi, from a trade policy perspective, how does the TRIPS agreement shape the cross-border supply of medicines and I guess just public health in general?
Thanks, Dr. Melissa, and thanks, Claude, for that introduction. It actually helps me now talk about the TRIPS with that context in mind, the context of how IP rights came to be and their connection with public health. So maybe to answer that question, I can just put a small note on the context around which this agreement was negotiated, because I think that's important. So up to 1994, which is when we had the WTO agreement, there was a lot of debate whether to include TRIPS in the context of this whole negotiation package, because it was not clear the relationship between IP and trade, and to that extent why we need to talk about trade-related aspects of IP. And there was a bit of a debate between the developed and the developing world about the nature of these commitments. And we were coming into the TRIPS agreement at a time when we had other conventions in place, negotiated in other contexts. So you have the Bern Convention, the Rome Convention, the Paris Convention, all of which govern different aspects of IP. So if you look at the architecture of the TRIPS agreement, basically we can divide it into 3 groups or categories. So you have the first category that brings out the principles and the objects, and, well, says that there's a balance between public policy issues and IP rights, i.e. ensuring in the long term we promote creativity, but at the same time addressing short-term needs like issues to do with public health that Claude has talked about, for example, the HIV/AIDS situation we had, or COVID. So that's the first part. It also has in it some basic principles like non-discrimination, so that you make sure you don't discriminate between different WTO members as you're enforcing IP rights. But what it did that is unique to other WTO agreements is grant individual rights to IP owners, whether it's a patent or an industrial policy design or geographical indications or copyright. It allowed individual owners of this IP to exercise rights in different territories. And so you have a part that talks about the rights and provides some like minimum standards for what these rights are. So in each territory you are protected, and it explains what rights you can enforce because of the IP that you have registered in that territory. Then you have another part that talks about introduces some sort of maybe flexibilities, if I may say, and I'm happy to expound on that, but for now I'll say that then they recognize sometimes it's not always possible to go through the voluntary licensing way because maybe medicines are expensive, or they're not affordable, or it's a public emergency situation. So it allows members to use what we call compulsory licenses that Claude has alluded to, basically allowing you to use the patent without the permission of the owner of the patent in certain situations. So you have provisions that allow you to import that product and to sell it domestically. And until 2007, we now have the amendment that allows you even to export that product under the compulsory license. So you have those flexibilities. The whole idea of the TRIPS agreement is to make sure enforcement of IP doesn't hinder legitimate trade, or in that sense doesn't hinder access, or doesn't hinder other members from exploiting or using the product or the process that they need. But like I said, there were other underlying agreements that had already been negotiated, like the Paris Convention or the Bern Convention or the Rome Convention. And all of this was skewed more towards protecting intellectual property rights than they were about access. So since before 2007, like Claude mentioned, when we had the HIV/AIDS epidemic, then this conversation came up. And WTO members, or I should specify developing country members, felt we have this epidemic going on, this agreement is not allowing us to access the medicines that are needed to deal with this public health situation that we are facing. So after a series of negotiations, the members concluded what is called the Doha Declaration on TRIPS and Public Health, that basically allowed now the use of, or clarified the use of a compulsory license, and the fact that you can actually export the products using that compulsory license, and clarified on issues of payment to the owner of that patent. And that was important at the time because, like I said, the priority was making sure the medicines are not just available, but they are affordable. But the discussion continued, and in 2020, when COVID hit and it was very devastating for everybody, the conversation came up again. And certain members of the WTO, India, South Africa, Kenya also supported that, came up with a proposal for a waiver, a TRIPS waiver, because they said, yes, we have compulsory licensing, but compulsory licensing is long and cumbersome as a process, and it doesn't help us deal with the access problem. So what we need is a waiver so that we don't have to apply the rules under the TRIPS agreement so that we can deal with this COVID situation. But as you would imagine, this wasn't met with a lot of grace or acceptance from the WTO members. And so what they had in 2022 after 2 years of formal and informal dialogues was a compromise. So that's what Claude was alluding to by talking about the ministerial decision on the TRIPS agreement. So what that did is it just clarified issues to do with the compulsory license. Fine, you can get a compulsory license, but you have to implement national legislation or systems to use that compulsory license properly. And that doesn't happen with many WTO members. So it clarified, by the way, for this COVID time, and it only applied to vaccines, I should mention, you don't have to have a whole statute to use the compulsory licensing regime. Even a decree is enough. And by the way, you can also exploit the opportunities you have to export this vaccine so that you make sure everybody has access to it. So it did a few things in terms of easing the process, because part of the complaint was this process is long and cumbersome and this agreement is not working for us. And we are dealing with a situation of a public emergency, or an issue of public health emergency. So that's what the TRIPS has, and that's what the waiver did, and that's what the Doha Declaration did. But I should also mention, increasingly it started becoming very important for developing and least developed countries to start to think internally, because if you look even at the literature on the TRIPS agreement, there's many people, and we agree actually, that the TRIPS, it doesn't help completely with these situations of public health. I mean, fine, it acknowledges that as an objective of the agreement, it's to create a balance, but does it really? So then it became a question of how then what can we do at national levels and regionally to make sure we enhance access issues, affordability issues, we create systems that allow us to exploit the flexibilities that are already there in the TRIPS, etc. And that's now when things like the AFCFTA agreement come in force, because they are helpful. They are helpful because they force you to look internally and to see to what extent, therefore, your systems can assist to make sure there's accessibility and affordability of medicine. So I'll stop at that, but that's just the basic framework of the TRIPS and what it does, and I'm happy to come back to it after. Thanks.
Yeah. But before I let you go, perhaps I'll just ask an additional question. Because it's true that TRIPS is very central to this debate. So I'm just wondering whether, from a developing country's perspective, you see TRIPS to be more of an enabler or a barrier?
Okay, so there's two sides to this story. Number one, there's the concession, and all of us agree that the TRIPS agreement doesn't necessarily enhance or assist with the issues that the developing country world have, which are accessibility and affordability. It doesn't, for sure. But then on the other side, there's what does it do? It creates flexibilities which you can exploit. The question then becomes, to what extent are they exploited? I think it's also important, in as much as I would concede that indeed the Article 31 and 31 based flexibilities don't necessarily deal with the issues of accessibility and affordability, that it's also important to introspect and look. I know Kenya has the Industrial Property Act, which, well, to a good extent covers issues to do with government use and compulsory licensing. But it's important for this to work that there is harmonization of internal systems, for example, at EAC level. So in as much as I would concede, in fact, it doesn't address issues of accessibility and affordability, it's also important to introspect and look at what our systems have and to what extent they actually exploit the existing flexibilities. Yeah.
So now I want to draw Chebet into the conversation. So Chebet, how do existing IP laws, principles, and protections apply to artificial intelligence? Because I know you've done quite a bit of research on that.
Thank you very much for the question and also for the other panelists. They've really set a good foundation on what traditional IP is. Claude has taken us through the history of why IP is important. And in emerging tech times, in AI times, we can think of it as we are in the position where many years later we'll be talking about the history of AI and IP. And so because it's not been as developed or it's an emerging field, unlike say trade laws, there are more questions than answers in terms of how does IP intersect with AI. And so Dr. Melissa, if I can, I want to start by asking a few questions to our audience here and also online. So how many people have interacted with AI? How many people have created with AI? Just put them high up. That's a good majority. How many of you think that you own what you created with that AI? Like 2 hands, 3 hands. Okay, so the rest of you think that, do you think that AI owns what you created using the tool? How many think that AI owns it? So who owns this? These are the kind of questions that we have coming up and are being discussed in court, outside court, and even here today. So when we're thinking about traditional IP, as Claude had mentioned, it's a property right. And there are different kinds of IP rights, right? So you have copyright, which protects the original literary work. And softwares under Kenyan law, softwares falls under that. Then you have patents, which protect the process of coming up with a new product. Then you have utility models, which are like a small patent. So the examination is not as extensive as a patent, but it also protects a new process, right? Then we have trademarks, which would protect, say, the Strathmore University slogan or logo that we have there. Then we have industrial designs, which protects the feel and the look of an object, say the bottles that we have right here. We also have trade secrets, which protect commercial information, which is commercially beneficial because it's secret. And we have geographical indications, which are a symbol or a sign of products that come from a specific origin. And so their quality is high depending on that. So for example, think of Swiss watches or champagne and Swiss cheese and the like. And we have traditional knowledge and traditional cultural expressions. So why I'm breaking this down is to see, it's for us to all understand, how do those traditional IP rights intersect with AI? So for each one of these IP rights, the creator or the innovator is a human being. So the protection, the right, and the right here, I mean the right to control the use of the IP. So the right to reproduce it, distribute it, translate it, adapt it, that is normally to a natural person. Also, it helps when there's an issue. Who's going to be held liable? It needs to go back to a human being, right? So when we come up now with AI, AI is not human. So can it really own these things? Those are the questions that are there. But can AI create something that is new? Can it create a new product or a new process? How many think it can create something new? How many think it can't create something new? I feel like more are saying it cannot create. There are very many things which we have even interacted with, which have been generated by AI. And they're actually new. At least I think they're new. But then it depends on the contribution of the human to figure out. So as much as AI does not have, in most countries, does not have an enabling law. So in Kenya, we recently had the National AI Strategy. In many other African and developing countries, we have AI policies, AI strategies that are coming up. In Brazil, they have a AI bill that's being, it's going through the parliamentary process. But most countries are creating enabling environments for AI innovation to grow, for us to be able to adapt AI in a manner that is both beneficial and equitable to all. But at the moment, AI is not going to operate or does not exist in a vacuum. So what happens is we're using the traditional IP to determine the governing of AI-generated outputs or AI itself. So when you're talking about a patent, you can get a patent for an AI where you're protecting the process of, say, coming up with the algorithm. For a copyright, you'll have a copyright behind the compilation of the data or the data set. And then in terms of trade secrets, you can also use it to protect the secret source of how the algorithm works. So the decision behind how an algorithm works can be protected as a trade secret. So that's how people have been using traditional IP as it is to protect AI. But there are more questions, as I said, than answers, because there are different nuances that come up, but at the same time, there are very many opportunities. Just by a show of hand, how many people have used an AI-generated e-health app? Like one, few people. So in Africa and other developing countries, we have AI being developed and we have AI being used. If you pass near the Daystar roundabout, near the Nairobi hospital, we have a big billboard which is advertising an AI tool for diagnosing and screening of cancer. So in Kenya, we're already using a lot of AI-generated apps or AI-assisted systems and softwares. There's also an app by a hospital in Kenya, I think it's Jacaranda Health, which is used for pregnant women. They use an AI system for them to get personalized SMSs, which helps with the antenatal care. So development is happening in Africa and in developing countries. It's more about what can we either reform in our IP laws or figure out if there's need to change things or to come up with new ways in how IP and AI can intersect. But it's already happening, in short. Yeah, thank you.
Thank you very much. In fact, that has answered one of the questions that I had for you, which was about, if an AI system develops a new diagnostic tool or treatment protocol or a health data set, whether that can be called original for the sake of, copyright or patent. But I think you've already alluded to that. So you want to add something?
Just to add a little bit. So most of these questions are being handled in courts. And currently, one of the questions that's being handled in court is, how does the court determine whether you can get a patent of an AI-generated tool? And here, one of the things they're asking is, okay, was there a human who heavily contributed to the making of this output? So this means the human had to constantly change the prompt, create the prompt, revise the output. And so if a court finds that, okay, here there's a human that has heavily contributed to it, then you can get a patent for that. One other big case that we have had going about is one called the Dabas case. And this is by a gentleman called Dr. Thaler, a very ambitious gentleman who has filed a claim for a patent in very many countries. He tried in the US, he tried in the UK, and other European countries, and in South Africa. And here he was claiming that the AI should be listed as an inventor. In most of these countries, the court simply said no. The AI is not a human and therefore cannot be an inventor. In South Africa, they did agree and had it accepted as a patent. However, the difference here to note is that in South Africa, their procedures are a bit different when they're coming up, granting a patent. So it's more of a procedural check, tick, 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 as opposed to like an extreme examination behind the claim of the patent. So in that case, the answer would be it depends. Yeah.
Thank you. So I want to bring the conversation back to trade. Let me just circle back to Jambi. So you mentioned about flexibilities, and just to pick up on that, which trade flexibilities would you say matter most for trade in pharmaceuticals?
Thanks for that question, and let me just appreciate Chebet's intervention. Because I do think that the systems, to your question, which flexibilities are useful? Well, there's a lot in the TRIPS as at now that can help facilitate trade or ensure trade happens in that there's access to affordable pharmaceuticals. The first one that I'd say is we have the compulsory licensing recognition under Article 31 and 31 bis that allows you to use without the permission of the patent owner their patented invention for pharmaceutical products and to export them. In 2022, in 2007, what the Doha Declaration did, which was eventually included in the text of the TRIPS, was to clarify how this compulsory license works and to expand the scope from domestic use only to exportation. So this is something that can be helpful. But I must say that in that regard also, you have to recognize that the compulsory licensing regime is not self-executing at the TRIPS level. It also depends a lot on what's going on at the national level. So if you look at Kenya's Industrial Property Act, for example, you'll see that we have provisions that now clarify on the procedures for you to get or to acquire compulsory licensing. But sometimes there's issues. So I know, for example, there was a time Cosmos Pharmaceuticals tried to get this, but then it wasn't very successful. But it also was a product of some inconsistencies from Ministry of Health to Ministry of Trade and how you apply or you approve this compulsory license. So even though that flexibility exists, then if it's not executed at national level, then it's not helpful to you because it's not self-executing. You also have parallel importation that allows the product that has already been patented in one territory to be exported to another territory. I'm trying to simplify it here, with the recognition that the moment you get that patent in this territory, then you exhaust your rights there, and we have that provision in the TRIPS agreement. So then this allows a patented product that is received in country A, and it is cheaper there, can be exported to country B if the company does not allow access of the same product in country B at the same or a cheaper standard. So then that importation process then allows the product to be used in country B at a cheaper price. And this is a flexibility that exists. So if you look at Article 6 of the TRIPS agreement, it talks about exhaustion of the IP rights, and it allows basically this to happen. But again, it depends on how then you harness this at a regional level. According to me, there is opportunities even at AFCFTA levels to use these parallel importation procedures so that the products are accessible to other territories at cheaper prices. So these are some of the flexibilities that exist in the TRIPS. Also to note is that if you look even at the definition or the qualification of what is a patent, for example, you don't have, the TRIPS doesn't define for you what innovative step means. It doesn't define for you what industrial application means. It's for you to define for yourself. So if you have strict provisions or if you have broad provisions, then it can speak to how well then you use the minimum standards that exist to enhance policy space or to make sure then that you have laws that are a bit more flexible. What the TRIPS agreement, and I can comment this on all WTO agreements just generally, what they've done for countries like ours is allow policy space for issues like, for example, ensuring then we are able internally to coordinate and make sure there's access. What they don't do is provide market access properly, but they do provide some policy considerations. So the TRIPS agreement is not perfect, but these flexibilities that exist can be used, if used properly, can be useful in ensuring accessibility and affordability of medicines. Yeah.
Thank you. Let me draw Claude in so that then now he's not too silent. And just to build up on what Njambi has been talking about, so how do global political and economic pressures shape the ability of countries like Kenya to use TRIPS flexibilities?
Thanks, Dr. Ari and Njambi and Chebet for leading us to this point. This is the age-old question about the interaction between IP and trade, right? Because we understand that at the very beginning, at the very basic point, bilateral and multilateral negotiations are not, first of all, are not heterogeneous, and second, are not, as a result of power imbalances or characterized by power imbalances. So by the mere fact that these institutions fundamentally are situated in the West, the biggest donors of their budgets, if you talk about the WHO, for example, 18% of WHO's budget is financed by the United States, right? Well, up until Trump withdrew with an executive order as soon as he was elected in November last year, right? And then that is by far and away the largest contribution to this global entity compared to any other country. The next country is perhaps Germany, I think, comes in at around 3 or 4%. So it can't be lost on you what the geopolitical tensions are, what the priorities are. And if you look at a lot of the litigation that has happened at the WTO on the TRIPS agreement, a lot of this has revolved around these global elite players, typically at the instigation of pharmaceuticals or large multilateral corporations initiating their actions. And in fact, this fear itself was kind of ingrained in the negotiation and the subsequent adoption of TRIPS provisions in developing countries. Because initially, the fear was that developing countries will be subjected to an explosion of litigation from developed countries because of the at the time perceivably stringent requirements of TRIPS, to the extent that they are mandatory. They are minimum standard, but they are mandatory. So this was the fear that kind of anatomized the responses by developing countries towards developed countries. Now, has this materialized? Njambi has noted some tensions that already exist. The imbalance between producing powers, who have the originator drugs, who have the genetic data sets, who have the technology to push development. Those tensions do exist. But we want to ask more specifically, what has the initial apprehension about TRIPS resulted into? Now, the studies show, and evidence shows that the influence of TRIPS on domestic policy making in developing countries has been significant, just not in the sense that it was originally thought. Instead of having led to an explosion of litigation against developing countries due to the perception that they would be found non-compliant, what has actually resulted is, by and large, a practice or tradition of over-compliance, right? Because the response is then driven by apprehension. If the response is driven by apprehension, then most of these countries are likely to adopt what we call, TRIPS plus, obligations or standards, whereby they go over and beyond the requirements of TRIPS. And this has fundamentally been because of geopolitical pressures, again, at the instigation of developing countries with lawsuits, at the instigation of multinational corporations, public pressure, which has led to some of the bolder countries and less malleable countries, for example, South Africa, which has been at the forefront of pushing back against the paradigm of unrelenting old IP, stringent IP, has led to the isolation as compared to, or with respect to other developing countries, because then countries that are more malleable tend to overcomply. So then the driving force, the impetus behind the attempts by less malleable countries such as India, such as Brazil, such as South Africa to reform the TRIPS process is kind of hindered as a result. So it's fundamentally political, but that is not to mean that the decision making at that level is also not objective. We do have the WTO dispute resolution system, which all TRIPS complaints go to that system as a default requirement of membership in the WTO and accession to TRIPS. We do have that forum which provides some degree of standardization, but that has also been questioned because the attitude that has been adopted, Jambi had spoken about the thinking behind introducing TRIPS within the WTO framework, despite having all of these other treaties and instruments related to intellectual property. So that reality as well has kind of manifested in the decision making of TRIPS, which is that IP is a very different, the nature of IP is that it should give room for national priorities by states in terms of your policy making and decision making. Why? Because the needs of innovation are not heterogeneous. For example, Japan would value software licenses or more protection for software licenses because it wants to grow that sector, and less protection for, or because it's well advanced in that sector, and less protection for pharmaceuticals, for example, because it has, it's now done really well as a biotechnological ecosystem, but historically it hasn't done too well, and China also historically hasn't done too well until quite recently. So then they value different things. So when it comes to decision making, IP is meant to allow those, and TRIPS itself, the language of TRIPS, is meant to allow nations to set their own public health priorities in times of national emergencies, public health crises, and so on. So the problem, as I close, is that TRIPS decision making has been seen, WTO decision making relating to TRIPS has been seen as overly trade reliant. Trade doesn't operate under the same premise of sovereignty and fundamental agenda setting by a country in the same way that IP does. So then that has led to a bit of a tension in the decision making. But in some, my thinking is that the decision making forum provides a bit of neutrality, but it's also not perfect for reasons that we could expound on here. Thanks.
Thank you. In fact, as you were speaking about those challenges, I was just thinking about something that Chebet had talked about in terms of the AI health models. So this is just perhaps a follow-up on something that you had talked about. So when the AI health models are trained, most likely they're trained on real research data, patient records, etc. So what copyright and patent challenges does that pose?
Thanks. So yes, for you to have an AI model or an AI algorithm, it requires a lot of data, and it requires a lot of data and a lot of high quality data. So most AI developers will get this data either from the web, publicly accessible information on the web, and this is publicly available because possibly it doesn't have any copyright behind it, or it's in the public domain. But they can also go the other step where they use web crawlers, where they just go and collect information. Sometimes, most times, this information or this data has copyright behind it. So, as I mentioned before, for you to use copyright, you need to have permission from the owner or the author, right? So if you collect a lot of data and you use it without permission, this brings about copyright infringement possibilities or claims. So many times you'll have the AI developer, or we've come across a case where an AI developer has done both. So they have gone and gotten books legitimately from the internet, like bought books, and then used that to train their data, but also gone to the illegal pirating sites and gotten books, and then also trained their data on that. And this is the current case that has gone on in the US court. And the court found that for the data that it got legitimately, this was fine. And this was fine because they used an exception, or rather the defense they used was an exception for copyright called fair use. So fair use or fair dealing is an exception where you can use copyrighted work without asking for permission, and it's not infringement. Fair use is in America and in other countries. In Kenya, we have fair dealing. So the difference here is that for fair use, it's a bit more open-ended. So it's based on four factors. So you're looking at the nature of the work, the amount that is used, the purpose that the data has been used for, and the effect on the market. So in these cases, the court said that, you know what, the defendant did not really do anything wrong because they took this information just to train their data, and so this is fair use. If you look at it from the Kenyan perspective, if an AI developer was to go on the internet and collect health data, so let's put aside first the issues of data protection and privacy, which are big issues in the health sector. So let's focus on the copyright part. So if they collect all this data that is owned by different people in copyright, if someone claims to use the exception of fair dealing, so fair dealing in Kenya is more strict. It's a set of uses which are permitted. So you can get copyright, use it for certain purposes without asking for permission. And this include scientific research, parody, pastiche, caricature, if you're reporting on news or current events, and education. So when we look at it from the AI perspective, if an AI developer has scraped the web of information without permission, does this really qualify as scientific research under our law? And so would it be acceptable? Unfortunately, because the way it's put in the law, it's a bit ambiguous, and the law didn't really anticipate emerging tech like AI. We're left to be a bit in limbo. You can go to court and argue and defend yourself and say that I need training data for me to develop this AI, which might become a health AI tool. So I am using this as an exception. But since it's not very specific to us and we have not had any interpretations by the court, it still is a bit in limbo of is this an infringement claim outrightly, is it not? Yes. Thank you.
Okay, thank you. And I see time is moving very fast, so I think I will now move us towards a discussion on policy and reform considerations in relation to what we've talked about. And I can start with you, Njambi. What kind of reform dialogue around TRIPS or IP frameworks do you think is realistic in the next decade?
Realistic. Okay. So let me start by saying what's going on now. So what's going on now is post-COVID, there was the recognition that there is serious intersections between what the WTO is doing, between what WIPO is doing and WHO are doing. So now we have a trilateral working group between the WTO, the WHO, and the WIPO. And they have constant dialogues and talk about the different intersection points and what each institution can and should do and what is realistic. Now, to your question, there's been a lot of discussion about Article 71 on review of the TRIPS agreement, and that this review should be more consistent so that we are not blindsided when we have another pandemic and we are saying, oh, actually this doesn't work, we need another ministerial decision, we need the ministerial when they meet in Geneva to actually talk about this. So the constant reviews to me would be useful to make sure that the problems that, God forbid, but another pandemic would bring, then we are able to foresee. Within the broader WTO institution, there are reform discussions going on, just broadly, not within subject matter reforms like the TRIPS or the subsidies or whatever, but really just about the institution or the vehicle of the WTO. There's a lot of feeling that it's becoming more and more, and I'm using this word loosely, but irrelevant to address current issues, not just in IP, I should say. This is a debate that is happening across the board. And part of the big problem is how decisions are made at WTO level. Legally speaking, they don't have to be made by way of consensus, but they usually in practice are made by way of consensus. Getting 166 members to agree on something is very difficult. This is not 1994. We have more members who have acceded. And I should also mention we have accessions like countries or economies like China and economies like India that have grown. And at the WTO, you self-declare in terms of your development status as a developing country member. And this point plays a big role in even how we understand flexibilities. Developed economies are not willing to discuss special and differential treatment, for example, in the context of the TRIPS, because this special and differential treatment will apply to developing economies across the board, including China, including India, including Brazil, that have grown significantly since the inception of the WTO. So there's broader reform institutions that are happening that could also impact what happens to the TRIPS, but to me, what's more realistic is to keep the trilateral working, because out of these discussions, we are seeing proposals like, and I was mentioning this earlier, like public procurement, and the place of public procurement in helping countries like ours get more affordable and accessible medicines. Because you can negotiate better if you procure as a pool, and you have more leverage compared that if you're one state. So the idea is that countries can come together. So, and this was birthed out of this trilateral. The WHO, the WIPO, and the WTO did some research, and what they discovered is that there's potentials in how countries handle public procurement that can help them enhance economies of scale and also get accessible and affordable medicine. So to me, that's realistic. Keeping the three people talking is realistic. Talking about constant review of the TRIPS agreement is realistic. More things like waivers and amend Article 31 or 31 base, not realistic.
That was a good answer. Thank you for that. So to Chebet, if you had to choose which is more urgent, would you say we need stronger IP frameworks for AI or safeguards for equitable access?
Can I answer like a normal lawyer?
Yeah, sure.
It depends.
And then unpack the it depends.
Yes. So, okay, the quick answer I'd say is smarter IP. So IP's goal is to incentivize so that we can have more innovations, more creations. At the same time, it's supposed to help you recoup your costs, your investments, your time, and all of that. However, if you have too stringent IP rights, as Jambi has said, it locks out people from accessing IP goods and services. So when we're talking about it in the context of health, it becomes a lot more real because it's between life and death. It's not about making more money or not. It's about if this person does not get that vaccine, which happened during the COVID pandemic, many people lost their lives because of stringent IP rights. So when I'm saying smarter IP, I mean, yes, we need to reform and evolve our IP rights for them to be able to create an enabling environment for AI innovation and for us to be able to adapt it in a way that suits us. So when I'm talking about this, I'm talking about coming up with guidelines that suit us. So when I said about a patent and is there human contribution, getting us guidelines from IP offices which talk about to what extent do I need to have a human create contribution to this to become a patent. It also means using open licenses. So open licenses are, the most common that we have is Creative Commons. And this, it's a free license or an open license which has specific limitations on the use of a product or your IP. So if you have, say, an article and at the bottom it's written Creative Commons 0 or 4.0, whatever, it means that you're allowed to use this without asking for permission from the owner, but you have to use it in specific ways. So bringing it back to the African context or the developing world, the standard open licenses most of the time are a situation where it's a one-size-fits-all. It doesn't matter if the licensee, the one who's asking for the right, has more resources to use this information or less. So when we're talking about AI and data sets, and particularly African data sets, most of the time you'll get this data from a community. It won't be an individual person. And so there needs to be a situation where we have equitable access to this information for anyone, the African, outside of Africa. But there needs to be some form of benefit to the community that's getting this data. So when we're talking about smart IP, there's an innovation or a tool, a license that CPIT's director, Dr. Melissa Omino, and a Professor Chijioke Okorie from the University of Pretoria came together and they thought about this and how can we have equitable access to African data sets but at the same time benefiting them. And they came up with a different kind of an open license. It's called the, forgive me if I butcher it, Nuolite Obodo Open Data License, or NOODLE for short. So how this one works is that it creates a tier system for the users. So if you're an African or you're from a developing country and you give out the right to use of your data using this license, your data set using this license, then it means that the person who gets to use that data set, if they are an African or from the developing country, they have to share any modification or adaptation to whatever comes out of that data set within Africa or the developing country. And if it's for commercial use, it has to be outside of the African country or the developing country. But if you are not an African or from a developing country, then you have to give some form of benefit or interest to the community, depending on what they ask for. So sometimes this could be in terms of monetary form. Other times the community doesn't want the money. They want access to the data or access to technology for them to be able to process their data sets and come up with AI tools. So it means smart IP means just thinking outside the box and thinking what really matters to us, our interests, our needs, and coming up with new solutions that are best for us. Yeah, thanks.
Yeah, thank you for going beyond the it depends. Yeah. So Claude, as we come to the end, what kind of IP health balance, balance between IP and health, would you like to see developing countries actively push for?
I wish I had an AI in front of me to ask it that question, because it's a tiered question for me, and it's something that really matters to me, because I think a lot of things in this intersection have been misunderstood. And this relates to both practical steps at the national and international level, and what I care more about, the conceptual issues about how we perceive IP and what IP should actually do for societies, whether in the same way or in different ways. So I guess at the international level, I would, in terms of practical steps, before I get to the more interesting conceptual issues, would be, of course, I really like the work that's going on with the trilateral framework, WHO, WTO, and WIPO. But then, that's an ongoing conversation, right? But there are already challenges that you can spot within the position as it is right now. Yeah. Obviously, with respect to the flexibilities, my main challenge lies with the decision making. I think WTO panels, decision making panels, have to conceptualize, and most of these decision makers adjudicators are trained in trade fundamentally, have a trade background, so you forgive them for having this worldview about IP. I think there's a need to adopt more of a differential and human rights oriented standard in TRIPS decision making, just so that it's demonstrably different in terms of starting points from trade decision making, right? I also tend to think that there are a lot of inconsistencies and fluctuating conduct between countries. China's policy before COVID and China's policy after COVID, for example, for us to bank on any given country or power players to effect the change. So I think in terms of the flexibilities, it's important to interrogate and to understand that needs of countries are not heterogeneous, and we have to be differential and understand that each country, or rather decision makers and arbitrators, have to understand that each country fundamentally under an IP regime is entitled to set its own priorities. With respect to at the domestic level, I would like to see a bit of some more serious attention on questions of data exclusivity, right? So data exclusivity, this is it's a limited monopoly. It's a time-limited monopoly with respect to data, especially data that leads to therapies, especially in clinical trial settings or personalized medicine or individualized drug treatments, right? So what this does is it gives you secondary protection, sometimes broader than the patent monopoly, which is the strongest IP monopoly, right? But if you use data, if you have regimes that have data exclusivity provisions, China recently adopted the data exclusivity provision, which allows you to have exclusive rights over clinical trial data 5 years after your patent has lapsed, and you have the US with its quote-unquote Section 301 process, who kind of continue to push agendas in other countries to align their laws more closer to American laws. And this is not necessarily compatible with the unique public health needs of developing countries. So what tends to happen is countries would adopt these TRIPS plus obligations, for example, under free trade agreements, which is self-defeatist, right? Fundamentally, because there's no reason to believe that more IP protection, if some IP is good, the fallacy is that then more IP must be better, right? And this kind of transitions into the conceptual questions. I think we've conceptualized IP in a way that needs reconsideration, hence a division between, that I like to think about, between old IP and new IP. Old IP is concerned with, pushing for more IP at all costs, erecting high walls in order to protect yourself from others, protect your inventions from others. But studies have kind of shown in the past decade that, yes, IP does create an incentive, right? But I see IP has incentive effects in the same way that it has inhibitory effects, right? And between those two factors, inhibitory because sometimes, even if there's disclosure of the knowledge, you're precluded from using that knowledge. It's inhibitory. And more important for us as African countries is that you can't afford patented medications, for example, right? That's an inhibitory effect. It might incentivize Pfizer and GlaxoSmithKline, but not the individuals suffering with a particular malady. So then, which between those two, the factor that predominates, literature has shown, depends on the local context and the innovation system, which is the interaction between laws, institutions, and regulations in creating and disseminating technology within a particular jurisdiction, right? So then what that means is that we need to reconsider IP and what IP does. More IP is not necessarily better, right? It doesn't mean you should compromise IP protection standards. But you can think about embedding IP in an innovation system that recognizes that IP is not just about the laws, it's also about how people behave, right? How researchers behave, how scientists behave, and how they interact with institutions and innovation systems. So I think there's a bit of a reform dialogue that has to be had with respect to that. And finally, in terms of a very concrete measure to ensure reform, I see like two possible paths. You'd have technology transfer, right, and socially responsible licensing. Both of these respect the fundamental principles of IP, but socially responsible licensing goes ahead and recognizes that there is a public good at the meso and macro level, not just at the individual level, that should be pursued by an innovation system. And the avenue to effecting this is, one, reforming our contract law around material transfer agreement, data access agreement in clinical trials and genomic research, as well as our domestic IP laws. And finally, to kind of ensure a collaborative environment, because collaboration is the defining factor of a successful innovation system. And sometimes that can be inimical to insisting on strong patent protection. With that said, there's also an assumption which sometimes is not very well confronted, which is the idea that African countries will benefit more from less IP protection. I think to an extent that might be true, but it's reductionist, it's oversimplified, it's a lot more of a complex discussion than that. Thank you.
I know Njambi wants to add on, especially when I had, the conversation on FTAs, I kind of figured you might want to say something before my final question to all of you.
Yeah, I just want to agree very strongly with something that Claude has just said on dispute settlement. We have seen decisions like China IPRs or the issue with the Canadian patents, etc. And you see how, through the reasoning, it's about trade. And to a certain extent, I don't really fault that, because it is an agreement on the trade-related aspects. It's the intersections between trade and IP. But I just want to say that as part of the reform dialogue ongoing is exactly this type of conversation. And by the way, not just on IP, it's who makes the decisions about whether there is a violation of whatever agreement of the WTO. And part of what the discussion looks like now is perhaps we need to move away from these binding decisions that require members to bring measures in conformities in ways that are so expensive, and move to more non-binding kind of decision making, which, if we look at the track record of the ICJ with the advisory period, it doesn't necessarily mean that they mean less, but this can be an opportunity then to make sure we understand each other in terms of what does a violation look like. So I just wanted to clarify, that's also part of an ongoing dialogue, the dispute settlement and how that's done in any context, including the context of IP. But I agree very strongly with the fact that they are skewed more towards trade than they are about the policy considerations and other issues. Yeah.
Okay, my final question, and this is to all of you, so you can answer in any order and you can build up on each other's points, is if you are advising one African country today, what should they, or what one thing should they prioritize in their IP and health strategies? In any order.
Sure, thanks, Doctor. Just one thing.
Yeah, okay, you can say more than one, but
Yeah, okay. Three things isn't too bad. Okay. I think for me the most important thing is for developing countries to understand the importance of crossing the barrier or the bridge between old IP and new IP, right? The idea that IP in itself, IP outcomes are not determined by the law as such necessarily. They're also determined by behaviors of innovators and inventors in relation to institutions and their attitudes. So for example, in the medical research environment, if you were to speak to 10 medical researchers who are seated here, they will tell you, okay, we file patents all the time, but there is an implicit rule between us that you can copy everyone else's work to develop a certain invention subject to rules of data exclusivity or not. So they understand that the rules are there to be broken. Yeah, the patent establishment is not an end in itself, right? And the point is to maximize innovative capacities. And there are different ways, there are different aspects that characterize old IP, right, which is very strong exclusionary rights, data issues of data exclusivity, the absence of differential standards, and so on. So I think that's a very important thing that has to be done. The next thing I think is important is to regularize our infrastructure on data and metrics. Right? For us to have a serious reform conversation around IP, we need to have the data, and for us to have the data, we need to measure it. Yeah. So the data is a kind of the gold standard here, and some we have researchers and think tanks that have developed checklists on how to effectively capture IP and innovation needs, and to know in a context-specific way what a specific country should do. I have in mind, for example, the Center for Intellectual Property at McGill. We also have the International Expert Group on Intellectual Property and Technology Transfer. There are checklists that exist, but countries haven't really embraced this or haven't thought about them because it is not, apparently it's not seen that for you to have context-specific questions, you have to have empirical research, right? Which is now what I think animates some of my peers and myself in our research. We want to know what are the empirical questions on IP that need to be answered in this particular jurisdiction, because again, IP is not homogeneous, or rather, IP needs are not homogeneous; they are heterogeneous. No country's priorities are the same. And then finally, I liked the idea that Chebet had mentioned of Creative Commons in copyright. I'd just like to mention that even in medical research now, there's a growing practice to establish, what has been called the scientific commons. So the scientific commons has sought to kind of standardize licensing procedures and data access procedures between researchers in the biotechnological innovation space. So that's something to also watch out for. In other words, there's no IP law is as such is not the solution, because IP guides innovative activity, but innovative activity is subject to a more complex multiplicity of players and behaviors and attitudes, political and otherwise. Yeah. Thanks.
Thank you for giving us 3 rather than 1. So, but the rest can add on.
Yeah, obviously I'll just add, because Claude has been thinking about these things more, have to concede than me, and what exactly needs to happen, and what do we need to see at country level so that, well, we can have both creativity and address public health concerns. So I come to it from a trade perspective, and for me, my question becomes, what do we need to make sure there is both creativity and access in terms of exportation, sale? And I think about it because I just actually read the EACIP policy that projects to 2033. It sets the priority for the East African community when it comes to IP. And for me, that's important because that's a customs union that can have certain potentials, and if you focus on the right things. So part of what the policy wants to focus on has like 6 objectives. One of them is human resource and building skills, but there's infrastructural development. So it comes at it from a way that can attract investment, that can finance what you need to ensure that there is innovation, but not just innovation, that you're able to also produce and export and exploit economies of scale through the East African framework. So for me, that policy, and Claude, when you read it, I'd love to have your views on it, but that policy really just focuses on, the practical things that need to happen, the enablers to trade that need to happen. So that's where I come at it from. Of course, I agree with everything else that Claude has said is important to think about, but for me, that would be the priority. Infrastructurally, in terms of human resource and building skills, in terms of what types of investment are you attracting to finance this production or this creativity or these hubs. In fact, they talk about, which is of interest to me in particular, using special economic zones or industrial parks as hubs to ensure that you promote this type of creativity. And for me, that could create serious potentials for the community, and I look forward to seeing what happens in the next decade.
Yes, so from the AI or emerging tech perspective, so countries are coming up with AI strategies, AI policies, AI bills, AI laws. But one thing maybe we need to think about and remember is that AI is a tool, and so we already have laws which can support it and regulate it and govern it. Yes, think about it. But at the same time, I don't think we need to be in a rush to start coming up with new AI laws. And even when we do, we need to first always think about the context, how it's being applied in our local context, as opposed to looking to pick from the West who have come up with their own AI laws. So my advisory would be, yes, come up with reforms to the law to support and enable AI innovation and how it intersects with intellectual property, but at the same time consider the context and future-proof. So this means that come up with laws which can withstand emerging tech that comes about, so that not every other time we have something new coming up, then we're going back to amend. So thinking beyond just now and also making it very contextually applicable. Yeah.
Thank you. So a lot has been said. I mean, we've heard a lot about what IP is and that intersection between IP and health, and also how AI comes in. So as we wind this up, I would like to give each of you an opportunity to give your parting shot, in 1 or 2 minutes. What is it that you want the audience, both those who are here in person and those who are joining us virtually, to take home from this discussion? So your 1 minute parting shot.
Let me start and give Claude some time to think about it. Mine, I think I've already mentioned it, so I'll just repeat it. AI does not exist in a vacuum. The laws that we have, the IP laws that we have, affect, or it is bound by these laws until otherwise. The other thing is that AI development, AI use is being used in Africa. It's being contextually used in Africa, and that's something we need to think about. How do we create access and benefit to a community that gives up its data sets. Yeah, thanks.
For me, my parting shot would be that trade can provide unique opportunities to take the problems of the current world, or to solve the problems of the current world in a different way. So international trade and IP are not applying in isolation. And I'll bring this to the context of the AFCFTA. Yes, we are talking about the IP protocol, and we are waiting for the annexes to see what those will contain, including on emerging technologies. But we also have a competition protocol, and we also have an investment protocol. And all of this can create unique opportunities to build meaningful value chains. And of course, there's many layers to this point, for sure, don't get me wrong. But there are trade policy tools that can be useful and that are available already that can enable creativity but also deal with public health concerns that are facing the continent. So that would be my parting shot.
Thanks, Dr. Ari. Both of the other speakers are more thoughtful than myself. Yeah. I would speak from a more personal perspective, which kind of reflects my motivation behind having an interest in these questions. And this is leading up to the point that I think a lot of the interventions that we've had as a country have come from outside, and it behoves us now for us to think about internal approaches you can have towards these problems. Because if you think about it, a country like China has a very inward-looking, and now I'm sounding like a huge communist manifesto, communist Politburo fan. But I greatly admire a lot of the work that China has done in many ways, especially in transforming its internal approach to IP. For example, China set a goal to have, I'm not saying this is a good thing, but it set a goal, and it achieved it, to have 2 million patents being filed by the year 2012. And by the time they were getting to 2012, they had surpassed that target by close to 1 million, right? Now, 28%, around 28% of the biotechnological innovations happening in China as a result of artificial intelligence, a very quick response to a growing practice. China has also positioned itself very strongly, I think, in the international trade environment. So, for example, they're the leading I think second or third when it comes to biologic APIs, right? So it's high time as developing countries with very unique needs internally that we started to think about internal responses to problems. So, for example, my interest, maybe most people in the room did not live at a time where we had a very, strong and pervasive, pernicious stigma around HIV, right? I lost close relatives to HIV. I saw the stigma. In my immediate family, there's a cancer survivor, and I saw the stigma as well. So we need to think about the unique reasons why we think the questions we are asking matter, right? And why IP can generate solutions in that regard. So for me, the most promising avenue lies in shaping our own needs as opposed to our own biotechnological needs as opposed to other countries. So, for example, if you talk about cancer, in the US, the main problem they're facing, or in Germany, UK, the main problem they're facing is individualized drug treatment or personalized medicine. Can we individualize this medicine to fit your individual genetic profile, right? Here, the problems you're struggling with is, pap smears in screening for HPV vaccine, HPV infections, which is a strong predisposing factor to cervical cancer. We're facing questions around stigma, around prevention, around diagnostics, right? So our biotechnological focus has to be in that direction. And this is what IP, the scientific policy of the country on IP should be about. Now, our scientific policy, to the extent that there is one, it's not very clear, misses out on several key important aspects in terms of those needs. Yeah. So you don't know, for example, what we should do with intellectual property that has been publicly, or intellectual property resulting from research that has been publicly funded, right? The National Research Fund dispenses monies for grants every once in a while. It's very unpredictable. So sometimes people win grants and the money doesn't come out. So the domestic research stalls and so on. We don't have laws on data exclusivity. We don't know what the regime on data exclusivity clinical trials should be. We don't have rules on benefit sharing. Helicopter researchers come in, extract samples, do research, develop therapies that are working for developed countries but don't work for us. Good case in point is the Majengo sex workers. The foremost demographic in contributing to the vaccine, clinical and vaccine data for HIV. Most of them eventually just, died and succumbed to the virus. But the ARV medication, based off of their samples, is freely available, has been, well distributed in developing countries. So questions like those are what we should address. Again, it's not purely an IP issue. There are questions of ethics involved. There are questions of innovation systems involved, and socially responsible licensing. But we need to know our priorities. We need to set our priorities ourselves.
Thank you. So mine at this point is just to say a sincere thank you to Claude, Njambi, and Chebet for sharing with us your insights from your expertise, from the research that you have done in relation to IP, trade, AI, and health law. This discussion has been truly insightful because all of you put your A game into it in terms of, I can tell you're all very passionate about this, so thank you very much. And now I'll hand back to Martha to wind up the session. Thank you. Perhaps we can give them a round of applause as Martha makes her way here.
Thank you so much to our panelists. Thank you very much to our moderator for the afternoon. Just wondering, from the floor, do we have any questions? Start with you. Maybe we can take 3 quick. Yeah, sure.
Okay, thank you. My question is for Ms. Chebet. Yeah, so you mentioned smart IP laws, and one of the examples that you gave was maybe creating guidelines that stipulate how much human input you need for an invention to be patentable. But what then would you say about AI systems like DABAS that are autonomous and capable of bootstrapping, that need minimal or no human input? Then to follow up on that, I have like 3 questions. I'm sorry if I'm being selfish, but the next one following that is, would you say that putting or creating space for AI in our IP laws would have a negative impact on inventors, authors, creators economically? And then the last one is, I just want to hear your thoughts on what do you think about the argument surrounding training data sets with the whole like web scrapping and everything. under traditional interpretations of the reproduction rights and copyright. Would you say that if we interpret the copying that is done for the training to happen as reproduction, we can then just conclude it's infringement?
Okay, let's take those three first.
Thank you very much for your very well thought out questions. I'll answer them as best as I can. So your first question was about DABAs and what would happen if so if we have smart IP or coming up with guidelines, what that means to DABAs. I think it would help. So the issue that's at hand is that we don't have a lot to go by. So the next best thing is go to court and seek interpretations, or an IP office can come up with the guidelines. So currently that's happening in the US Patent and Trade Office. They are coming up with guidelines and saying, okay, this level of contribution means that this person can actually have a patent over it. I don't think it would apply to an AI or guidelines on what an AI can do, because the AI is not human. So it makes it very broad, I think, for you to start figuring out, okay, this is the level at which the AI can do this and this and this, and then it gets a patent. The other thing is when you think about liability. So if it owns the patent, who are you going to go after? And those are some of the issues that come up. Your other question was about if we bring in AI into IP laws, is that will it be negative? Was that the question? A negative economic effect to the creators, and I don't think so, because technology just develops and grows, and we make our lives more efficient, faster, more productive. From the very beginning of a wheel and donkeys, etc., like things just have to be digitized, or technology has to grow. So there are some negative effects. Currently we have AI tools which have overtaken a few people's jobs. They've automated things. So things move faster, but then also the human element is removed. But once again, I still think an AI is a tool. The same way you can think of a camera as capturing whatever is happening right now. You still need a human person behind that camera to direct, to edit, to figure out how it's going to be. So things will change. Some things will actually have a negative effect. Some jobs will likely change. But also there are opportunities. There are new jobs that will come. There's AI prompters, if that's the word. Prompt engineers, that's their name. So there are many new opportunities that come up with AI, as much as some we miss out, some we do gain. There was another question about copyright. Oh, okay. So in terms of web scraping, right? Can we call web scraping reproduction? There's actually a case around this. So there's a US case around this, and the court generally said that they don't think that falls under infringement, because they said that so you scrape the data, but you're not. So it was behind a book. You're not reselling this book as a whole. So for them, they're thinking that it's not reproduction because it's more being used as a transformative use. So they are collecting this data to make it into something else. The other argument that was there is that the AI doesn't look at things as words. So if it's a book, it's not looking at it as words, it's looking at it as machine readable. So it doesn't really have the same essence as reproducing, where you like copy. Yeah, but it's still something that's evolving, so it might change. Yeah, you're welcome.
Okay, any other questions? I can start with you.
My questions are it's actually one question, but I think both Claude and Janet can respond to it. It stems from Claude's statements on the WTO dispute settlement body and the decision making on IP matters from a trade perspective. So just to clarify, is it your position that there is something like inherently problematic about tackling the specialists of IP under a trade-related framework? And if so, what would you envision as an alternative? And maybe now to Janet, is there a conversation on this within the trade space about the intersectional concerns and the nuanced elements that are subsumed under trade, and whether there are problematic decision-making outcomes because they're being dealt with under trade? Yeah.
Thank you. My question is for Ms. Chebet. You had mentioned, in regard to the whole open or standard license conversation, you had mentioned the Noodle license program, and I think it's wonderful as part of the space of smarter IP, but two concerns come to mind for me. I think, well, firstly, the most common one that people run into is the bureaucratic issues when it comes to management of such a platform. So I was just wanting to know your takes on how developing countries can best come together and fiercely advocate for themselves, such that developed countries are actually contributing very, very useful data to this program. And then secondly, I was thinking about the issue of IP addresses and how regardless of where you are in the world, I think, for example, for like a platform like Netflix, you can just change your jurisdiction and you're able to access content from anywhere. So does the Noodle program respond to things like this, such that people in developed countries can just change and then they're able to access the database just like that? Yeah.
A final question so that we take them at a go.
The question goes to either of the panelists, but it's with regard with AI training data sets, particularly with regard to healthcare. So, like Claude said, for developing countries and any country, I think every country has peculiarities in terms of the diseases that are prevalent there, in terms of their also like genomics or the genomic data sets. They are really different. And I think yesterday I read a Daily Nation article that actually, despite the African genetics or genes being the most diverse in the whole globe, it's the most underrepresented in terms of the existing global genetic data sets at the moment. And we already know that some of these AI tools, before they come to us, they are developed out there using the Western-based data. And now, obviously, the conclusion to draw from that is most likely they might be inappropriate or at least ineffective for the population of like our country, or mostly the global south, or anyone who are an outlier within the training data sets. So my question is particularly, do you think it's tenable or rather practicable to impose a legal obligation that at least when we use or when they have these AI tools used in particular countries, at least there's a level of using of local data sets, or at least contextually comparable data sets in training, or at least sort of transparency on what training data sets have been used, so that we are able to gauge whether they could be useful to us or not, or whether there are improvements or enhancements that can be made before they are used within the particular countries. Thank you.
Okay, over to you.
Thanks a lot. I'll just attempt to answer the question by Kiwara and by Wilson briefly. Kiwara, your question, I'll leave the bulk of it to Janet. As I said, she's a more thoughtful person. So the question is whether I believe that there is an inherent problem with decision-making because decision-making is under the TRIPS, the WTO framework. My answer would be, if you insist that the qualifier here is inherently, I'd have to say no, because I don't think this is an inherent problem, but I think it's a demonstrable and clear problem with clear causes, right? And those causes are kind of linked to the nature of the power structure and under the WTO framework. Is there a solution advanced to this? Yes. In this respect, aside from the very basic principles that TRIPS requires deference to national priorities, and aside from the basic principle that paragraph 6 of the Doha Declaration that Jambi had referred to is now within the text of the TRIPS agreement, and therefore it is incumbent on the decision makers to make decisions with reference to those sources. Yeah. On top of those realities, there are measures that have been suggested and that are clearly workable and that are consistent with a differential standard with to TRIPS. So you have the balanced provisions under TRIPS, which can help resolve the problem of contextually insensitive decision making, because balancing provisions essentially as flexibilities allow the state to balance its priorities, right? You have the avenue of textual silence within the treaty itself. The treaty, for example, doesn't define what discrimination is. I think Jambi also mentioned that it doesn't dictate to you what the standard of inventiveness is, right? So these are things that go without saying about the nature of TRIPS itself. But a lot of the time, for bureaucratic reasons, they are ignored. Yeah. Is there scholarship to take this further? Yes, there's scholarship. You have scholars like Molly Land, for example, who've shown, in a technical sense, how you can depart from these weaknesses. Explained what the differential treatment standard is, differing to the state, and actually using concrete examples. For example, the U.S. copyright case, yeah, where the U.S. has been a tug of war with the panel because the interpretation of the panel is clearly very inconsistent with the national priorities of the U.S. And that's the thing. This is a size that fits all, because even advanced countries can benefit from some of these provisions. Yeah, so it doesn't have to be developed countries. Yeah, but as for the rest of the question, trade technicalities I leave to Jambi. I'll say something small about Wilson. Your point, you're right. You're referencing the article, I think, groundbreaking article by Charles Rotimi, the Nigerian professor, which shows that 99.9% of the human genome is consistent, but the rest is what gives you the variations that give you a genetic mutation that lead to a certain condition. Sickle cell, some types of cancer and so on, right? Now, the highest degree of genetic diversity is found within Africa, right? Which is still the most underrepresented in the genomics database, global genomic database enterprise. Now, is it as easy to resolve this problem by a legal requirement? I think your question is, should we have a legal edict saying, you have to source your data sets from this country, or, there'll be sanctions? I don't think that's necessarily a workable avenue, because of the fundamental researchers. Scientific researchers are driven by the right to science, right? The right to science also requires that no one can dictate to you how to investigate, what to investigate, right? Secondly, there are financial considerations. right? And scholarly aspirations. So for instance, what motivates medical researchers is to achieve groundbreaking research as quickly as possible and publish it within the target demographic of their jurisdictions as quickly as possible. So when you come to Africa, where you have potential confounding factors in medical research, then that delays the process of your research. Yeah, and not to mention questions with ethical approval, not to mention questions of a lot of these studies are backed or funded by entities that have a specific research agenda, right? Especially if it's a pharmaceutical company. So it would be quite impracticable to require them to adhere to such a legal standard. Now, are there avenues, technical avenues developed to ensure more equitable uptake of, and genetic representation in genomic research generally? Yes, and I'm happy to suggest to share with you some authorities that show you how to do this. But part of the groundbreaking research of this is being done by Professor Shaniqua Kalia at Georgetown University. So you might want to have a look at that. Yeah. But do I believe the law is an answer? I don't believe the law is an answer on this specific question.
So on your question on are there ongoing discussions, right now, yes, there are. I can situate the ongoing discussions within the broader WTO dispute settlement reform dialogue that is ongoing. But I would say in the context of the TRIPS, and you've talked about US copyright, I mean, you can read China IPRs. You will see that the limitations of the panel or the appellate body, as it were, is really on account of the text of the TRIPS or what we have, the interpretation and application of, because Article 7 and 8 of the TRIPS are truly, they reflect the policy space of the state, that's fine, but they are to be balanced against the existing IPRs within the TRIPS agreement. And like Claude said, a lot of what is in the TRIPS agreement relies on the enforcement, either by the judiciary. You can bring up the judiciary's measures or decision as a measure, or like what China did the other day with the Article 25 decision under the MPIA, which you can check out, or you can bring it up as they are allowing more policy space than is allowed, etc., etc. That, to me, has more to do with the architecture of the TRIPS than it has to do with the shortcomings of interpretation and application. Because even if we say there is a balancing act that needs to happen against Article 7 and 8, at the end of the day, there are certain rights that are granted to every patent owner, to every copyright, or etc. So to me, this discussion about interpretations should not start at panel or appellate body level and the role that they play. It should really start in the context of what reforms do we want to see in the TRIPS agreement. Like I said, what is realistic? I don't think that one is realistic, but if we're serious about it, that one can happen at that level. I should also mention that at least for non-violation complaints, there is a halt as far as members presenting non-violation complaints until the members agree on a further agreement with regard to the non-violation complaints. So what we have is only violation complaints. Non-violation complaints have a place that they play, and I'll explain what they mean. It means that you have not necessarily violated a provision in the TRIPS, but your actions nullify a benefit that I am owed within the multilateral trading system. Now, in the context of the TRIPS, you cannot bring that as at yet. Although one would argue that if you look at recent decisions, for example, the one under Article 25, it looks like it's a non-violation complaint kind of a thing, but you can't bring those as at now, at least until the members agree on how you can present non-violation complaints. So those limitations, to me, are more a function of what you have in the TRIPS agreement than they are about really the shortcomings in interpretation and application, even though I don't want to invalidate the point that there's people who are also concerned because the people who make this decision are trade lawyers like me. You need someone like Claude there as well, who also understands all of these different nuances that come with IPRs, etc. But I'll leave my comment at that.
Okay, I'll quickly respond to the question about the noodle license and the difficulty or the bureaucracy about African countries coming together. So the noodle license is a tool, yes, it's a license, it's a tool, but when we're talking about African countries coming together to enable themselves to take care of their data sets, benefit and equitably share this, there are bodies, there are regional bodies which can work. So in Africa, we'll have the ARIPO, Africa Regional IP Office. Ideally, the member states should come together to push for their agenda or to ensure that their interests are taken care of. At the World Intellectual Property Organization, in the different committees, say the Standing Committee for Copyright and Related Rights, the African countries move as a group. So they're called the African Group. So they stand behind each other, and that way they're able to amplify their voice. And this has been working well so far, because now they're able to get more of an audience, or if other members of the WIPO want to add them to, help them push whatever they have to now get on board the whole region. So that way, I think, is a good way, because now they're able to stand up for their own interests, and so far it's working, I think. Then there's also the AFCFTA and the IP protocol, which, if I'm not wrong, calls for harmonization, but that one will take a long time to talk about. And then in terms of talking about, you were saying about if you have a VPN and you're able to change your jurisdiction and access it. So for the noodle license, what you have to remember about it, it's a license, so that means it's a contract, which means that there's two parties coming together and agreeing. It also means that if one party breaches the agreement, then it's an infringement, and you can also get damages or find some form of recourse. So it's a contract like any other, and you can always seek relief in case someone has breached it. Yeah. Then to the question about transparency, I think on training data sets, just to add to what Claude had said. In terms of IP, we have the new WIPO Treaty on Genetics and Traditional Knowledge, which one of the things it talks about is if you have a patent that you have a patent application and it's based off traditional knowledge or genetics, then you have to disclose where you got this from. So if we transfer that to a training data set, then it helps in terms of transparency on where you're getting this data from, and also ideally should help in benefit and also access to those who are giving out these data sets. I think that's all the questions. Thank you very much.
Thank you very much. Another round of applause to our panelists. I think I must admit that the conversations have been very insightful, and I hope we've been able to draw a lot of knowledge just from all that has been shared, all that has been said, the questions that have been raised. And really, if I was to summarize, all I can say is that I see we've come a long way in terms of IP law, in terms of tech, in terms of, health advancements. And at the end of the day, the systems, the mechanisms that have been put in place, hopefully they are foolproof, are supposed to help all practitioners operate fairly, yeah? So even as we go forth with this knowledge, I hope it be useful for us, and that now we are able to engage more confidently and partake of these conversations. So thank you very much for staying through to the end, and have a lovely evening.